Hi, all. We're going to talk about the First Amendment and criminal procedure. And the two of them, as some of the readings you did, have not always been discussed in the same breath, even when the issues involving free speech have a great impact on criminal procedure. So, where I started with the reading was I had you read the case US v. Stevens, which, while it's a criminal case and involves the First Amendment, it's not necessarily the most important one ever, but it does, as a recent case, show you the sort of way the First Amendment gets talked about. And notably, it gets talked about as far as individual rights in a very different way than Fourth Amendment, Fifth Amendment, Sixth Amendment rights have been discussed in many of other cases. In US v. Stevens, it was a case about the sale of images of animal cruelty. And the Supreme Court said, based on the First Amendment, you can't make selling mere images of animal cruelty as a crime. Now, there were exceptions because people said, well, what if it's artistic? What if it's educational, etc.? And so the law said you can sell it as long as it has religious, political, scientific, educational, historical, or artistic values, leaving only, at least as the goal of the legislation, things like, in this case, what were known as crush videos, essentially taking pictures of the killing of animals because some people sexually get titillated by those images. It was especially in this case involving pictures of animal fighting. Now, the actual animal like fighting is illegal in all 50 states. So, why is it a problem with making it illegal to sell images of an illegal activity? And this follows discussions and debates over obscenity, child pornography, and so on over the years. And notably, the Supreme Court had made it constitutional to ban the sale of pictures of child pornography. But they, as the Justice Roberts decision said, they wouldn't extend that to pictures of animal cruelty. Now, what I want to focus on here is what Roberts argues is, not just it's illegal, they don't even want to look at the individual examples to say, does this fall outside of the artistic, educational, etc. examples? They just want to strike down the law altogether. You know, what they're trying to argue is that there's a standard in First Amendment where they don't do balancing tests. They don't look at how would a reasonable person approach it. All of the tropes we've seen in the Fourth Amendment. They just sort of say what's known as strict scrutiny. If there isn't a strong public interest, they're generally going to strike down any regulation of content in images. And they argue this case has alarming breadth. Since it could cover the wounding or killing of any animal, there's expressions that it might make depictions of hunting or other issues of great concern, at least to the conservative justices, or it might make farm killings and pictures of that illegal. Very important to many folks there. Now, interestingly, Justice Alito, who is usually with the conservatives, was the dissent here. I will say, from folks who had clerked with him that I know, he just happens to be an animal lover. So, this is one case where his personal views definitely intersected with his arguments. But they're important arguments in this case because he argues, look, there are all the exceptions. It's not over breadth because they've already covered all of the concerns the First Amendment would have. So all this leaves is something that's already illegal, dogfighting and taking pictures of it. They don't believe it would ban any great amount of protected speech, and if there is any that comes up, that could be litigated. They think that, as he says, just striking down a law because it's potentially going to have overbreadth shouldn't be something the court goes to too quickly. They should actually allow things to be made illegal if it is actually constitutional to make those particular aspects illegal. Now, he does note that first, a lot of the things Justice Roberts argues might be regulated are, in his words, fanciful hypotheticals. You know, most states protect hunting, it's not illegal. There's no reason to believe that there's any substantial danger of things people value being regulated due to this law. Um, and he notes the reason you do this is it's hard to catch people doing these illegal acts, such as killing animals, torturing them, just like it is with child pornography, which is why they allowed the banning of the sale of child pornography. If people are doing illegal acts and profiting off of them by selling the images, going after the sale of those images may be the only way to stop the actual illegal act you want. That's at least Justice Alito's argument. Now, whichever side you end up on, and that's fine either way, the important thing I want you to focus on is this is a very different structure of debates on rights. The idea that if anything the government does might in some way deny somebody anywhere their individual rights, we have to strike down the law, is not at all how any of the laws we've talked about, whether it's mandatory minimums, whether it's other punishments, whether it's stop and frisk or anything, all of that has often had languages like, well, if in general, if on balance, if a reasonable person would think that this was okay, they'll generally at least discuss allowing it and often will litigate the individual examples to say, well, is this constitutional or is this not constitutional? But First Amendment is far more like a light switch. Either the law is legal in almost all circumstances, or it's going to be shut down altogether. And that gets us to the next reading, which was on copyright. Because copyright is all about making speech and images illegal. If images of, killing dogs can't be criminalized, you'd think that a picture of Mickey Mouse, you couldn't be thrown in jail for distributing that, could you? Except, of course, copyright says that if you distribute images that are owned by somebody else recognized under copyright, you can be thrown in jail for quite minor amounts in some cases. There is, unlike this idea of strict scrutiny over breadth, the Supreme Court says once it's involving copyright, which notably has its own provision in the Constitution giving Congress their ability to regulate it, which is one reason why First Amendment doesn't come in as strongly. But it is interesting that dog cruelty completely protected. Picture of Mickey Mouse completely unprotected by the First Amendment. And what's interesting is when punishment is made for copyright, they don't basically have any discussion of proportionality. Even the degree of punishment, whether it's criminal or civil, doesn't really have much First Amendment debate, which, as the reading notes by Margot Kaminsky, is quite different from Europe. Europe, while they also protect and will punish copyright violators, they really do go really into the individual issue to say, how much are we going to punish it? That's all about, does the government have a legitimate purpose in regulating it? Are the means of pursuing copyright violations related to that purpose? Is it the least restrictive means of protecting fundamental rights of speech and artistic freedom? And you have to really balance the law against the cost of going after infringement. All of that goes into the European discussion, as opposed to the US is, did you download the pictures, the movie, whatever it is, and did somebody else own it? You lose. This is an interesting question that commercial crimes involving speech, whether it's securities fraud or a whole range of other areas, also have relatively low First Amendment speech. If speech is involved in general traditional commercial areas, the discussion of speech is very different from what gets even near political or artistic areas. And that might be as it should be, but it does create a rather dramatic divergence in how the courts talk about it, and a divergence from how they talk about areas, as I've noted, the Fourth, the Fifth, the Sixth Amendment that we spent most of this course talking about. And, you really have to think about why other courts around the world weigh artistic rights versus intellectual property rights versus free speech rights. And as this case notes, there are a large number of areas where copyright enforcement goes right to some of those core political issues. For example, the US has often seized entire websites with content infringing materials, even if the rest of that website might have vibrant free speech activity having nothing to do with the commercial violations. Yet, because there was a commercial violation, they'll take out the rest of that pure political, artistic free speech that would normally be protected. So, you know, as she notes, quote, one prong of the US criminal copyright standard requires only that the infringer intend to break the law. And as long as there's that motivation to break the law, it almost doesn't matter if there's a motivation even for financial gain, if it's within this copyright world of no First Amendment. And she does make the note, while other countries have more of a proportionality basis, the US, through trade agreements, has actually been exporting our much tighter, much more no compromise view of copyright to other countries. And that brings us finally to the Daniel Soloff, the First Amendment as criminal procedure piece, because what he notes is it's hard to separate, as so much of evidence, so much of our commercial activity is itself often in email form, is often electronic, a form of speech. The regulation of commerce, the regulation of government is very speech, at least adjacent. And so there is some interaction between the First Amendment and the Fourth Amendment if there is a subpoena to obtain documents. There are often some First Amendment concerns raised of, are you only going after the documents that are relevant to the case? Are you in any way infringing on First Amendment rights? So it's never, not that the First and Fourth Amendment never interact, but they really do live in different worlds, both within criminal procedure. Although I will note, going back to the original MAP decision, I noted at the time that this was a case that was treated as a warrantless search case, but was about finding and prosecuting a speech violation. But because the First Amendment hadn't actually evolved fully into its current no compromise version, they actually concentrated on the Fourth Amendment side. While that case would have gone completely different today, since the case would have been thrown out on purely First Amendment grounds. But here's one of the things Solov notes. If you can search through Fourth Amendment, search and procedure, which can have much looser standards as we've seen compared to the First Amendment, the emails you see, the social media you see, who people are sending the email to, what's often called metadata, you can see the whole network of associations people have, which has incredible impacts on the core First Amendment values we have of association and speech. And yet, as your textbook will show, there's very little about the First Amendment taught in criminal procedure. Most First Amendment scholars don't really pay that much attention to criminal procedure, and vice versa. You end up with this very different language about constitutional rights in First Amendment versus Fourth Amendment. Criminal procedure, as I noted, talks about reasonable expectations of privacy and balancing tests and reasonable government behavior. First Amendment law says we need strict scrutiny for where government action is barred unless, quote, narrowly tailored with a significant government interest. So, very different language, different results. And, there is no question when people talk about constitutional law, the First Amendment generally has a more privileged status. The Supreme Court itself has said, quote, the First Amendment is the matrix, the indispensable condition of nearly every form of freedom, which may be true. But as we've talked about with copyright and other areas, some speech is more equal than other speech. And within a whole set of areas, there's issues about do you need anonymity to foster speech for unpopular decisions? There's fears of government surveillance that could stifle political speech. And is this whole issue of what is the status of personal documents that aren't necessarily protected under the Fourth Amendment or under the Fifth Amendment, especially when those documents are with third parties in the cloud, for example. And one of the realities is under criminal procedure, it's far easier to search a commercial business, Facebook, Twitter, Instagram, whatever it is, or a bank where your records are, versus your home. The Fourth Amendment, as we've seen, is very concerned about the location of the search. But we live now online in so many ways that the concern about location actually defeats many of the standards of constitutional protections in the Fourth Amendment that we were most concerned about. So you have this issue of procedure around probable cause, but a radical change in substance of where most documents are located. And so the limits on police searches are generally less effective than even they were, but the impact on First Amendment rights may be far greater, even as the courts barely acknowledge this shift. And Solov ends up by noting that the Fourth Amendment and First Amendment were once much more tightly rooted. Like the right to trial in like what was a famous case of John Peter Zenger in 1735. He was tried for seditious trial, and his right of the jury, like around that, was very much tied to a set of procedural rights in like criminal procedure as much as it was any idea of the First Amendment, which notably didn't yet exist, but was really a precedent for many when they sort of thought about the rights under the Bill of Rights. So I'm just going to end this by noting that it is a very interesting part that we really have to think about how rights interact. And we've seen that at points with the Fourth and Fifth Amendment interacting in Miranda, for example, and we've seen other rights interacting. But thinking about how the First Amendment and the Fourth Amendment and the Fifth Amendment all interact and how that might change a more holistic view of rights under all of the amendments is worth thinking